So, if one looks at Section 73 of the Indian Contract Act, it very clearly states that compensation for loss or damage caused by the breach of contract, the party who has broken the contract is entitled to give that compensation to the party who suffers such loss or damage due to the broken contract. However, Section 73 very clearly underlines the rule that the loss or the damage that naturally arises in the usual course of things are the only kind of damages that are available, which clearly brings you to the fact of the distinction between direct loss and indirect loss, or what we call as direct damages or consequential damages. Now, in India, in ordinary contracts, only direct damages is awarded. However, in say infringement of intellectual property rights, the courts may grant you some consequential loss. So, depending upon the kind of breach of the contract, there could be some kind of variation. But the ordinary rule, which looks at implementation of Section 73 of the Indian Contract Act 1872, very clearly says that the loss should have naturally arisen from the breach, and it is something that should be in the usual course of things, and that's all what is going to be entitled you to get damages. So, interestingly, if I can give a simple illustration of what can be damages, is let's assume that I have promised to, sell something to you. Say it could be a laptop, and the price of the laptop is around 60,000 rupees, and I do not, after making a contract, actually supply this laptop to you. Now, what should be the damages in case I fail to supply this laptop to you? Now, it cannot be 60,000. Why? Because you have to actually pay me 60,000 if I deliver that laptop to you. So I have actually saved you that 60,000. You have not actually incurred any kind of loss, even though I have breached the promise and I have not delivered the laptop to you. So that is not that you can give proof of damages, and that is not something that you can actually be entitled to, though it can be considered as something that has naturally arisen, but the loss is not naturally arising, right? What is the loss in the usual course of such a breach of contract if I don't supply that laptop? Let's assume that, okay, you need this laptop. Obviously, I agreed for 60,000, but the same laptop, now that you have to go to the market and buy it at 70,000, right? Because of my breach, now you have to go to the market and buy this laptop at 70,000 rupees. Please note, this difference between 60,000 that I promised and the actual price at which you bought is 10,000 rupees. The difference is 10,000 rupees. And this difference has naturally arisen in the usual course of this contract and is a consequence of the breach that I committed. Had I performed, you would have just spent 60,000. Now that I did not perform, you have to buy it at 70,000. And the difference of 10,000 in what was agreed to what you actually buy is the kind of loss or damage that is caused to you. And that is all you will be entitled to as the direct consequences of my breach of not selling that laptop. So now if you look at laptop example and we try and say, look, there are other kind of losses that have occurred and why can't we claim damages for that, then we have to discuss what are the other kind of losses that may suffer. Now, look, the contract was supposed to be performed on 1st of May and I did not perform. And it took some time for you to understand that there is a breach. And by 30th May, you went and bought this laptop, though at a difference of 10,000 rupees. Now, these 30 days that unfortunately occurred of a delay due to my breach, you lost, say, opportunity to do some presentation. And if you had done the presentation using this new laptop, you would have got a new contract. And if you got that contract, you would have made profits. Now, can for all these, I who had agreed to supply this laptop to you, can I be made responsible for the same, right? For the kind of losses that might be anticipated. Sometimes you may say, sometimes not known, something that was not foreseeable, but something that you want to substantiate and say, look, these are the kind of losses that I could have occurred or that has already occurred to me, right? So everyone who supplies laptops must know that that is critical, time is important, they will use it, it is of business value, and it can result in profits. and anyone who actually fails to supply the laptop must also be responsible for the same. Is something that people can definitely argue and bring that discussion forward as well. So the principle of remoteness of damage, it very clearly says that look, uh, you are liable to pay damage for the loss caused by you, okay, not for every loss that the other party has suffered, right? So he was supposed to make a presentation. He was supposed to get a contract. He was supposed to make profit. I'm not sure whether I have actually contributed to that kind of loss, right? How was I sure that one laptop will result either in profits or loss? Is it something that I have contributed? Is it due to a natural cause of my fault? This is something that people will have to answer before they claim damages. So, one is what is the natural course of things in the usual contractual business? Where is the breach occurred, and what is the realistic direct loss that is caused to the other party? Second, it is important that sometimes you will notice that the parties, if they knew that look, the consequence of breach can be A, B, and C, and hence I've already informed you that this could be the loss that I incur, then there is a possibility and a chance that look, that is not remote, because the party knew it. The party was told about it. He was informed about it very well in advance that this is required for the presentation. The presentation has this value. The contract is due, and hence, if you don't give it, this is the loss. So, if that is already known and the breach occurs, then because of that kind of a knowledge, it's not something that is remote to the contract breaker, and he may be responsible to compensate you for those kinds of losses that were brought to his knowledge, that was brought to his information as well. So, though they may be consequential, they were something that were already informed to the other party. Second rule is that when you talk about additional losses, again, when it comes to consequential or additional losses that are known, you must notice that there must be a direct cause and effect theory, right? So you cannot, even if I say something to you beyond what is the cause and effect, cause of the contract to the effect of the breach, then the courts are not going to give it to you just because you have mentioned it to it, right? So there must be a causation, there must be a link to the direct loss, and it must be a result of the breach, right? It should be a kind of a chain of events that have occurred due to the breach and not beyond it. And most importantly, the courts will apply the reasonable man test, and they will probably give damages that are just necessary enough to compensate you, that can, in a reasonable man's expectation, be something that can be awarded. But, again, the reason simply being that the principal rule of unjust enrichment applies to law of damages in India. So while you talk about equity, you talk about contracts in various stages, even in the stage of remedies, the courts will apply unjust enrichment and say, look, you cannot award damages that will make him rich or unjustly, right? You must give damages that should be adequate enough to compensate him, but not make him rich otherwise. So reasonability and unjust enrichment will actually tie the hands of a judge and make him do equity and not unnecessarily create some kind of a profit or profitability to the one who seeks the same. And what is important is that this kind of a foreseeability of the kind of losses that can be anticipated for the other party must be such that is made at the time of the contract, not at the time when the breach occurs. So when I made the contract, can I actually foresee that this is the loss that can happen to the other party? If yes, or if it's not foreseen, it is communicated, then I shall be liable for it, not otherwise. Now, a couple of cases that one would want to look at is this Hadley versus Baxendale rule. I think in this case it was very clearly held, and please note this was before the 1872 law, and illustration 1 of section 73 actually says exactly what this case is about. And this case very clearly says that look, if a common carrier delays in the delivery of a crankshaft to an engineer, right? Uh, you know, did the common carrier really know that the delay will cause losses apart from just being the delay of delivery, right? So I think the court here very clearly said that you can be liable for those kinds of losses that can be generally foreseeable by a reasonable man. So if I am a carrier and I am delivering something to you, and if there is a delay, For that delay, whatever is the kind of pro rata loss, I may be responsible. But suppose you don't get this crankshaft into your engine, and because of that you lost customers and profitability, business. How will a common carrier or a delivery person ever know what is this used for, how valuable it is, how many customers or profit you're making? This is not something that people will know, especially if you're a common carrier, right? So yes, delay is to be made actionable and accountable, no doubt about it. But you cannot force expect them to foresee your business, your loss, and expect them to actually cover those kinds of losses as well. The second case is the Victoria Laundry case. This is also a very interesting case, which says about profits, because what this case very clearly says is that, um, see, you can be made liable for loss of profit. But again, over there in profit, it is the general and ordinary profit loss that can be covered, not extraordinary loss of profits, right? So, when damages are awarded to you, you are not going to be lucratively, rewarded for the breach that is committed by the other party. Yes, if you decide that yes, profits have to also be granted, or what we call as interest have to be granted. For example, under Section 74, we say interest on damages can also be awarded as penalty. And the courts have consistently held that penalty in Indian contract law can also be given over and above damages, but in the form of a penalty if it's so required in that particular context, right? So profits also ordinary. That is something that is expected loss due to the kind of lucrative business that you are running, and because of the breach, that lucrative business is no longer lucrative. So to that extent of what is the benefit that has been lost in the business, that can be covered, but it's not the extraordinary loss of profit that will be covered in the contract. This is also a similar case whether the loss of profit was too remote. Again, it was a case of cargo that was delayed by 9 days. It was actually sugar that had to be delivered between two destinations. Interestingly, because of the delay of 9 days, the sugar market fell at Basra, and they actually had to sell the sugar at a loss. If it had arrived on time, they would have actually made a lot of profit. So they said that, look, for the loss of profit, you should actually compensate us. So, can a carrier that deliberately deviates it on its voyage, right, knowingly that a delay may cause loss, can that be held responsible or liable? Was the question in this case. Now, interestingly, the ship owner in this case had knowledge of what he was carrying, and he was very sure that it was a very, very essential commodity. It was meant to sell at Basra on a particular date, and there was a high probability that had the ship arrived on that day, it would have been sold for some profit. And the captain of the ship and the it was a chartered ship in any sense. So chartered ships cannot have deviation. So that's one important rule, and the entire ship had to actually only serve one customer. So deviations cannot be justified in any manner. And if suppose the delay was of 9 days due to some other events that were not within the control of parties, probably the court would have taken a lenient view, but not otherwise. So in this case, I think because of the rule of probability, I think profits were also granted in this case, because that was something that can be easily anticipated and should have been granted to the parties.